This controversy has quickly grown into far more than a routine royal headline. According to several recent reports, attention is now shifting toward the financial consequences surrounding Prince Harry's legal battles and what they could mean for the Sussex brand. One date stands above all others: July 29th, when a scheduled court hearing is expected to determine financial liabilities that, until now, have remained uncertain. To understand why that hearing matters, it's necessary to revisit a statement published nearly 2 years earlier. In August 2024, a former employee connected to the Archewell Foundation told People magazine that Meghan fully supported Harry but hoped he would eventually step away from the endless legal disputes. According to the source, she wanted him to enjoy life without being weighed down by constant courtroom battles and ongoing conflict. That hope never became reality. Instead, the legal case continued through a lengthy 46-day trial, ending with all 97 claims being dismissed. Following the July 7, 2026 ruling, estimates placed the combined legal costs at roughly £50 million, while insurance reportedly covered only part of that total, leaving an estimated £22.6 million still unresolved. Those remaining costs are expected to be addressed during the July 29 hearing. The ruling immediately dominated headlines. Prince Harry lost his case against Associated Newspapers, and commentators argued that the defeat carried not only financial consequences, but also reputational damage. As Harry appeared publicly at Chatham House shortly after the judgment, discussion shifted from the lawsuit itself to what the loss could mean for the Sussexes moving forward. One detail from the earlier People interview suddenly received renewed attention. The same source claimed Meghan understood Harry continued pursuing these lawsuits largely because of his commitment to protecting his family. Yet when the judgment was finally delivered, Meghan remained in California while Harry faced the aftermath alone. Critics viewed that contrast as noteworthy, although others argued there may have been practical reasons behind the decision. The larger issue, however, extends beyond personal circumstances. Supporters of the Sussexes often remember 2024 as a period when multiple commercial projects were still moving forward. Netflix remained an active partner, new business ventures were being promoted, and the legal battle had not yet reached trial. At that stage, there appeared to be enough financial flexibility to absorb potential setbacks. By mid-2026, the landscape looked very different. Reports suggested the Netflix partnership had changed significantly, commercial momentum had slowed, annual operating expenses remained substantial, and the court case had ended unsuccessfully. The financial environment surrounding the Sussex brand was no longer the same as it had been when that earlier warning was reportedly made. That explains why July 29 has become such an important date. According to multiple published reports, the hearing is expected to determine how the remaining legal costs will be allocated, whether additional recovery mechanisms may apply, and exactly who will ultimately bear responsibility for the uncovered expenses. The legal questions are now replacing speculation with documented court proceedings. Another aspect drawing attention comes from reporting published shortly after the verdict. Several outlets noted that, before the trial began, representatives connected to Prince Harry had reportedly explored the possibility of reaching a settlement through informal channels. According to those reports, discussions included the possibility that both sides might simply end the litigation while covering their own legal expenses. No agreement was reached. The case proceeded to trial. Evidence was presented over several weeks, and the court ultimately ruled against all of the claims. That sequence has led some observers to ask an obvious question. If settlement discussions were being explored before the trial began, what changed? Why continue with a lengthy and expensive legal battle that ultimately resulted in a complete defeat? Those questions remain part of the broader public debate surrounding the case, and they are likely to continue as attention turns toward the upcoming costs hearing. Another detail that has drawn significant attention comes from reporting published shortly after the verdict. According to The Times, Prince Harry and several other claimants reportedly explored the possibility of resolving the dispute before the trial formally began. The report stated that representatives acting on Harry's behalf used unofficial channels to approach Associated Newspapers in hopes of reaching a settlement before courtroom proceedings moved forward. What makes this especially notable is the reported timing. The outreach allegedly took place in December 2025, several weeks before the trial opened in January 2026. According to published accounts, One proposal under consideration involved both sides ending the litigation and accepting responsibility for their own legal costs. Had such an agreement been reached, the lengthy court battle and the enormous legal expenses that followed might never have happened. However, those discussions reportedly failed. Associated newspapers declined the proposal, the trial continued as scheduled, and after weeks of testimony, the court dismissed all 97 allegations. The case that some reports suggested both sides had once considered ending quietly instead concluded with a sweeping legal defeat for the claimants. That sequence has prompted fresh scrutiny. After the judgment, Prince Harry publicly described the ruling as a whitewash, arguing that justice had not been served. Yet the court's written decision focused on a different issue entirely. Judge Matthew Nicklin concluded that while the claimants believed unlawful methods had been used, the evidence presented during the trial did not prove those allegations to the legal standard required by the court. That distinction matters. A court finding based on insufficient evidence is fundamentally different from an allegation that the judicial process itself was unfair. Legal analysts have noted that public criticism of a judgment may become relevant when courts later consider questions surrounding legal costs and litigation conduct. Attention is therefore shifting toward the next stage of the case rather than the verdict itself. The hearing scheduled for July 29 is expected to determine how the remaining legal costs will be allocated, including the estimated £22.6 million that insurance reportedly does not cover. Legal commentators have also discussed whether associated newspapers could seek recovery under the indemnity costs principle, a mechanism that can allow successful parties to recover a greater share of their legal expenses in certain circumstances. For now, those questions remain unresolved. The court hearing, not media commentary, will determine the financial outcome, making the next phase of the litigation just as closely watched as the trial that came before it.